Hello, everyone. Welcome to Restaurants Canada's Navigating the Changing Employment Law Landscape, Bill 148 and Equal Pay for Equal Work webinar. My name is Lauren Vandenberg, National Vice President, Government Affairs with Restaurants Canada, and I'll be your moderator today. The implications of Bill 148 are far-reaching and of serious concern to restaurant operators across Ontario. Restaurateurs throughout the province have had very little time to adapt and adjust to more than 60 labor reforms and a steep increase in the minimum wage. These drastic regulatory changes have bred confusion and uncertainty across Ontario's food service industry. Restaurants Canada is lobbying hard for changes to the bill, and we encourage you to join our campaign. Tell the government your story and share how Bill 148 will impact your business by visiting www.savefoodservicejobs.ca. Along the way, we're partnering up with stellar firms like Williams HR Law to help our members navigate this ever-changing landscape of labor costs. In this webinar, you will learn about the amendments to the Equal Pay for Equal Work provisions in the Employment Standards Act 2000. You'll be able to assess how the amendments could impact your business. And together we'll explore practical strategies and best practices to minimize risks and meet new equal pay for equal work compliance responsibilities. Plus, much, much more. It is now my pleasure to introduce our speaker for today's session, Laura Williams. Laura is the founder and principal of Williams HR Law Professional Corporation and Williams HR Consulting. She has more than 2 decades of experience providing strategic advice and legal representation to employers on a full range of labor and employment law matters. Laura is also regularly engaged as a workplace investigator and has conducted investigations across virtually all industries and sectors, including food processing and distribution, retail, entertainment, professional services, community agencies, security, insurance, construction, engineering, and energy. She is a member of the International Women's Presidents Organization and serves as the legal advisor within her Toronto chapter. She is the past vice chair of a United Way funded agency and former governor of Holy Trinity School in Richmond Hill. She also serves as a volunteer for Life, the Lawyers International Food Enterprise. Laura, thank you for being with us here today. Before we get started, I'd like to remind you that you can submit questions by typing into the questions area of the control panel. You may send your question at any time during the presentation. Today's webinar is being recorded and will be made available in a few days, and participants will be sent a link to the webpage. Finally, if you would like to follow along on Twitter, which we highly encourage, we are live tweeting today's webinar using the hashtag Bill148. I would now like to turn the webinar over to Laura to begin her presentation.
Thanks so much, Lauren, and welcome to everyone this afternoon for the Navigating the Changing Employment Law Landscape, Bill 148 and Equal Pay for Equal Work. I can tell you in my 20 some odd years of practicing labor and employment law that the changes that we've seen in 2017 that relate to Bill 148 and many, many other pieces of legislation that have been enacted, it's just been overwhelming for employers across the board. I say this not only as a lawyer or a legal practitioner, but also as an employer, which has 2 firms and just knows the impact of these very broad sweeping amendments on businesses across all industries, and particularly on smaller employers. As Lauren has already set the table with respect to what we're going to cover today, and that will include reviewing the amendments to the Equal Pay for Equal Work provisions of the Employment Standards Act, assessing how the amendments could impact your business, and explore practical strategies and best practices to minimize risks and meet new Equal Pay for Equal Work compliance responsibilities. I want to start off first by a question that I get, with a question that I get from many employers who frankly are overwhelmed, and many of which are taking kind of the ostrich approach, hoping this whole thing will blow over and they won't have to deal with it, which realistically is wishful thinking. With kind of how did we get here? So what exactly led us to these very broad-reaching amendments to the employment standards legislation? So first, with respect to the road to Bill 148, many of you will be aware of the fact that this all started with what was called the Changing Workplaces Review, which was a review that 2 fairly prominent labor arbitrators were tasked with to really review the conditions and employment conditions in particular in Ontario with a specific focus on how employment conditions were impacting a particular segment of the of employment in Ontario, and that is those that are constantly caught up in precarious employment opportunities. So this Changing Workplaces review, which commenced in 2014, essentially looked at all aspects that were relevant to how precarious employees were being impacted, and ended with the final report in May 2017. Now, the final report issued in May 2017 included a number of recommendations, not all of which were taken up and included in Bill 148, which was first introduced in June 2017, and as many of you know, received royal assent on November 27, 2017. Now, the amendments came into force from November 2017 and January 2019, with most of the amendments having come into force already on January 1, 2018. Now, the amendments that we're going to focus on for the purposes of our webinar today will be coming into effect next week, and they will be in force as of April 1st. So with respect to the focus of the Changing Workplaces review and ultimately the Bill 148 amendments, it's important to understand the lens through which the Equal Pay for Equal Work amendments, along with the other Bill 148 amendments, evolved. So the stats and trends set out on the slide capture the focus of the Changing Workplaces review, which was to address some of the issues that are enabling barriers to employees caught in precarious employment opportunities from achieving full-time permanent employment. So the stats include that less than 25% of Ontario workers are estimated to be fully covered by the provisions of the Employment Standards Act. So what that means is that by virtue of maybe some intentional and maybe some unwitting kind of behaviors of employers, not all employees are being covered by the Employment Standards Act. And as many of you will know, the Employment Standards Act essentially sets the backbone of entitlements, so the floor, the minimum standards that have to feature in every employment relationship in Ontario. Also, the fact that there's a relatively limited number of Ontario workers fully covered by the Act also relates to the fact that there are a number of exemptions and exceptions that apply so that employees in certain roles are not covered by the legislation. Another stat that was considered in the context of the evolution of the Bill 148 amendments is that many workers have unpredictable, varied hours of work that create challenges for employees in managing their personal lives. This misclassification largely relates to the fact that many employers may choose to characterize the relationship that they have with employees as being arm's length or independent rather than being employment in nature, which would mean that they would be covered by the terms of the Employment Standards Act. And finally, it was recognized that private sector union coverage rates in Ontario dropped from approximately 19.2% in 1997 to 14.3% in 2015. And that was taken into account from the perspective that many employees that are engaged in precarious employment opportunities could benefit from having unions as their representatives to ensure that they receive their due and right entitlements under legislation and otherwise. Now, as Lauren had mentioned from the outset, there are some very significant implications to the Bill 148 and also very staggering impact on the economy. Now, there was a study that was commissioned by the Keep Ontario Working Coalition in partnership with the Ontario Chamber of Commerce and other employer and industry associations. And essentially the findings of this study assessed that approximately 185,000 jobs are at risk in the next 2 years. There'll also be a $12 billion impact on the economy in Ontario. Now, this was essentially cast as $23 billion impact that was set off by a stimulus of $11 billion through various government initiatives, but there still is left a $12 billion impact on the economy. as well as the inflation rate is set and expected to increase by 50%. So very, very significant impact as a result of these amendments. And with respect to enforcement activity, it's really important to be aware of the intended enforcement activity by the Ministry of Labour related to the ESA generally. However, particularly in light of the new Bill 148 amendments, the Employment Standards branch of the Ministry of Labour is planning to increase the emphasis on promoting compliance. Essentially, it's been pledged, and a number of new employment standards officers have been hired. The number that are slated to be hired and to enhance the existing complement is 175 employment standards officers. Now, the province plans to launch a program to educate employees in small to medium-sized enterprises about rights and obligations under the ESA. I believe it's acknowledged that and as it rightly should be acknowledged, that the impact and implications of these new changes, which were very quickly foisted upon employers, will have a kind of staggering impact, and it will be very difficult for employers to find their way through meeting compliance. But also, it should be noted that after 2020, the Ministry of Labour intends to resolve all employment standards claims within 90 days, which is a very accelerated time frame when you consider how they tend to languish through the system currently. But it's also intended that the Ministry of Labour will increase their inspection activity, which currently sits at about 1% of Ontario employers or Ontario workplaces in any given year, to 10% by 2020. So it is the case that a lot of employment standards, claims and compliance activity is still claims driven or complaint driven. But you can't overlook the fact that there will be a heightened and intensified focus by the Ministry of Labour to ensure that employers are keeping up with their compliance requirements and understand what compliance looks like now that we're in this new world order under Bill 148. So now I want to specifically focus on the equal pay for equal work changes, which, as I mentioned, come into effect as of April 1 of this year. Now, one thing with Bill 148 that was a little bit of a disadvantage to a lot of employers is the main focus of the bill when it was tabled that seemed to eclipse all the other proposed changes was the minimum wage increase. And of course, the minimum wage increase has a very staggering impact on a number of industries, including on restaurateurs. But certainly there are a number of other changes that I know have been covered in previous webinars as well, a little more intensively, that will have very significant and is having very significant impact on employers as well. So with respect to equal pay for equal work, I want to give you a bit of a spoiler alert regarding the specific impact of this change on employers. So, of course, one thing it's going to result in is a loss of flexibility and discretions that employers have typically enjoyed when setting wage rates, particularly as it relates to employees of various statuses. However, the one thing that is heartening about this set of changes, as opposed to some of the others, is that taking proper compliance measures will help employers properly navigate and mitigate the impact that these changes could have. And there are specific provisions and notably exceptions that will allow employers to mitigate the cost impact. So with respect to reviewing the equal pay for equal work requirements, let's first look at what the original what is in existence right now up until April 1 next week. So essentially, one thing you should note is that under Part 12 of the Employment Standards Act, there is already a requirement that employers maintain wage parity as it relates to employees on the basis of sex or gender. So this specific provision has been in effect for well over 40 years and specifically indicates that no employer shall pay an employee of one sex at a rate of pay less than the rate paid to an employee of the other sex when they perform substantially the same kind of work in the same establishment, their performance requires substantially the same skill, effort, and responsibility, and their work is performed under similar working conditions. So specifically, with respect to the existing provisions, you'll note that the Employment Standards Act addresses equal pay for equal work, but right now it only relates to sex or gender. Employers are not required to pay part-time, casual, or temporary employees or temporary help agency workers at the same rate as their full-time counterparts. Part-time, casual, and temporary employees on average earn just over half as much as full-time employees. And it's notable that temporary positions, including fixed-term contracts, have been the fastest growing employment sector in recent years. So some of these realities are what were taken into account when the legislators specifically considered the equal pay for equal work enhancements to the requirements that are in existence now. So with respect to the changes, what you should note, as I mentioned, is that as of April 1, 2018, differential payment on the basis of employment status will be prohibited where part-time, casual, seasonal, and assignment employees, and just to be clear, assignment employees are employees of temporary help agencies that are deployed to their clients to perform work. So the prohibition, so to speak, is that they can't be paid differently where they perform the same kind of work in the same establishment, use substantially the same but not necessarily identical skill and effort, and take on the same responsibilities, and work under substantially similar conditions. So what you should note, and what should be clear from the reference to assignment employees, is that this new change will apply to the employees of temporary help agencies. And just to refine one aspect of the new change is the definition of establishment. So you should note that an establishment, for the purposes of this provision and under the ESA generally, means a location at which an employer carries on business. Now, if an employer carries on business at more than one location, separate locations will constitute one establishment if the separate locations are in the same municipality, or one or more employees at a location have seniority rights that extend to the other location under a written employment contract. So it's very important to bear in mind that if you do have multiple locations in the same municipality, they will be considered one establishment for the purposes of the legislation. Now, with respect to the qualification of substantially the same, you should note that it means substantially the same but not necessarily identical work. So this means and refers to the main characteristics or core duties of the work. The work does not have to be identical or interchangeable. It has to be substantially the same. Now, while job postings, job descriptions, employment agreements, etc., may inform what the work involves, we anticipate that if there's ever a challenge to the comparison that the employer is implying to the work, particularly if the employer is taking the position that the work is not substantially the same, what will be assessed and scrutinized is the work that's actually being performed. So that's what will likely come under evaluation. Now, just to give you a sense with respect to how this typically plays out, well, let's look at Wilson's Restaurant. Okay, so Wilson's is a restaurant that employs both full-time and part-time employees. Part-time employees generally do not do more than 20 hours a week. However, they're scheduled fairly heavily to reduce overtime costs during peak times, including holidays. Full-time and part-time employees perform the same work. Part-time employees are paid, on average, 20% less per hour. And, this is very common and typical, particularly in any industry where you may need to ramp up staff fairly quickly, or employers wish to leverage some cost containment by using employees of different statuses, so casual or part-time employees. And essentially, it's not uncommon across industries, including certainly this industry, to pay those employees at a lower rate. So this is specifically what the equal pay for equal work provisions are aiming at impacting. Now, with respect to unionized environments, to the extent that it applies, it's important to note that in unionized workplaces, if a collective agreement is in effect on April 1, 2018, and if it contains a provision that permits differences in pay based on employment status, and there's a conflict between the provision of the collective agreement and the Bill 148 amendment under this part, the collective agreement will prevail, but only until the earlier of the date the collective agreement expires, or January 1, 2020. So as of the latest date, January 1, 2020, all workplaces, including unionized workplaces, have to be in full compliance. Now, as I mentioned, and when I had issued my spoiler alert, there are some very helpful exceptions to this set of changes that, in my view, make these new requirements somewhat navigable. So essentially, the exceptions are that different rates of pay will be permitted if based on a seniority or merit system, a system that measures earnings by quantity or quality of production, or any other factor other than sex or employment status. Now, I actually want to go back to this for a moment because it's really important to note that if you consider that there are certain workplaces that already identify different bases as to why employees may be paid differently, or in preparation for and in anticipation of these new changes coming down the pike as of next week, these exceptions are really helpful because it allows employers to consider and justify a basis for paying employees that are of different employment status other than full-time differently. And it's very helpful if you note the final exception, which relates, it's a general catch-all, which is any other factor other than sex or employment status. Now, that any other factor isn't further defined, and there's currently no guidelines as to what would properly fall within this catch-all provision, but it does give employers some license to really look at how they operate and to consider whether there are other bases to distinguish paying employees of different statuses differently than their full-time counterparts. With respect to other aspects of this new equal pay for equal work New World Order as it relates to employment status, you should note that there is now an entitlement for part-time, casual, and temporary employees, as well as temporary help agency workers, to request a review of their wages if they do not believe wage parity is being achieved. So this simply means that an employee who believes they're not being paid fairly can ask the employer to essentially review their wages and to determine whether or not they are not meeting compliance with the equal pay for equal work provisions of the ESA. Now, the employer's obligation is to provide written responses to these requests, setting out the employer's reasons for disagreement if they are not going to make any wage adjustment in response to the employee's request. And it's also notable that the legislators anticipating that there could be some pushback from employers, they wanted to ensure that they establish this entitlement so that employees can make these requests with impunity. So essentially, there's a reprisal protection, and that means that employers cannot retaliate not only against the employee who's requesting a review of their wages, but any employee who shares their wage rate, let's say a full-time employee that the requesting employee is trying to benchmark his or her wage against, that full-time employee also will be provided with reprisal protection under the legislation. There's also some other prohibitions, so to speak, that they've included under this section of the Bill 148 amendments. That includes that no employer shall reduce the rate of pay of an employee in order to comply. So an employer can't, recognizing that an employee, let's say a part-time employee, may have a legitimate basis for requesting wage parity, the employer can't then turn around and reduce the wage of the full-time counterpart. Also, no trade union or other organization shall cause or attempt to cause an employer to contravene the requirement of this part. And no client of a temporary help agency shall reduce the rate of pay of an employee in order to assist with compliance. So the main focus here is not allowing an employer or any other person to do an end run around these new requirements under the legislation. So in terms of seeing how this could play out, let's look at another scenario. We have Tessa. Firstly, what if Tessa is being paid less because of her part-time status? Well, if she is being paid less because of her part-time status, once the equal pay for equal work provisions are in effect, then the employer is, if she makes a request, is required to either make the wage adjustment if there's no justifiable basis for the employer to establish that there is an exception to the fact that that Tessa is being paid differently than her full-time counterparts. And if Joanne disagrees with Tessa's belief, really the only option that would be available to Joanne is to, ensure that whatever exception that could be applied to justify the wage disparity between Tessa and her full-time colleagues is a justifiable exception as per the exceptions that we just reviewed, and that allow employers to pay employees of different statuses differently. It is important to note that if an employment standards officer finds that an employer has paid an employee less solely based on employment status, the officer will determine the amount owing to the employee, which shall be deemed to be the employee's unpaid wages. So essentially, when there are challenges to whether or not the employer is in proper compliance with these new equal pay for equal work provisions, it is up to the employee to file a claim to the Employment Standards Branch of the Ministry of Labor, and the employee's claim will be assessed and adjudicated. And of course, if it's found that the employer isn't in compliance, then the employer will be required to pay any outstanding and owing unpaid wages to the employee. Also, it could be the case that it's not a result of a complaint or a claim filed with the Employment Standards Branch of the Ministry of Labor. It could be through an inspection that an employment standards officer visits an establishment and determines that an employer is in violation of these new requirements under the legislation. And the issue with that why you wouldn't want to be found in out of compliance, is because likely this would result in a much broader audit of the employer's pay practices. And if there are a number of violations of the legislation, coming into compliance and paying out the unpaid wages to the various employees that are impacted, again, could have pretty significant cost consequences for the employer. So really, the upshot with respect to the implications of these new changes on employers include that employers will need to ensure that they review the possible exceptions to navigate these new changes, so that they still can leverage some of the cost containment strategies that have been available by using employees of various statuses. And of course, if you can't rely on any of the available exceptions to the application of this section of the Employment Standards Act, employers will be required to pay employees of different statuses at the same rate. So with that, let me help to part the clouds with respect to compliance strategies, just to help you to, as you go about meeting these new requirements. So first strategy that I'd recommend is you really need to take stock and evaluate your existing policies and practices for compliance, identify gaps, and really strategize how you can go about resolving the gaps. And as we just discussed, the changes themselves do provide those exceptions, which can certainly be helpful. But beyond that, really what you should be reviewing is your current workforce in Ontario to determine if any employees at an establishment are performing substantially the same kind of work, requiring substantially the same skill effort and responsibility under similar working conditions and determine whether or not they're being paid different rates. Now, you should note that the new provisions related to equal pay for equal work limit the ability to vary pay rates based on employment status, such as full-time versus part-time, but do not apply to differences in pay rates between employees of the same status. So there's no right of a full-time employee to request a wage review related to how a full-time counterpart is being paid. This is really to address equal pay for equal work performed by employees of other employment statuses, such as your part-time, casual, temporary, and assignment employees. Second, review and consider new entitlements to ensure not unintentionally providing a greater right or benefit. So under the Employment Standards Act, remember, again, as I mentioned, the standards in the legislation essentially set the floor or the minimum entitlements that have to be present in employment relationships. So the legislation is very clear that if there are greater rights or benefits provided to employees, that those will also be first of all, it's allowable for employers to have greater rights or benefits, and it's often the case that employers do institute greater rights or benefits. But if you do have a greater right or benefit than the minimum, those will be enforced. And so this applies to generally all of the Bill 148 provisions, as well as the other provisions in the ESA. However, respecting equal pay for equal work, there may already exist a legitimate, justifiable exception to the application of the new requirements that should be recognized and leveraged so you don't make any unnecessary changes. So essentially, when you're reviewing your existing practices, if you already have exceptions that you can leverage so that you don't have to be concerned about ensuring wage parity, then ensure that those are recognized and that you confirm those practices. Also, number 3, review positions to determine whether roles are substantially similar in effort, skill, responsibility, and working conditions, and whether they fall within an exemption. So, essentially, under the employment standards legislation, there are a number of exemptions that apply, and that for certain roles, they won't fall under the purview of the employment standards legislation or a part of the employment standards legislation. So, for example, when it comes to equal pay for equal work, the legislators made it very clear that an employee who's a student under 18 years of age and who does not work more than 28 hours per week will not be subject to these provisions, or will not have entitlements under these provisions. So you really want to make sure that you're clear on that. Also, you should explore possible applicable exceptions to maintain wage differences based on employment status where justifiable. So I've already mentioned this in a number of areas, but certainly, as I mentioned, the specific exceptions under this provision, under these changes, does make it very navigable for employers to still leverage paying employees of varying employment statuses from full-time employees differently. So really examine how you can explore and leverage the exceptions, and also what could constitute any other factor than the ones that are specifically stipulated under the exceptions. And finally, you should be transparent about pay and compensation programs that could give rise to pay differences based on employment status. So in this regard, you should reflect applicable exceptions in job postings, job descriptions, and agreements. So you're being straight up and upfront about the exceptions that will apply to various roles. You also want to ensure that policies and employee evaluations reflect performance metrics that may be assessed and which could give rise to differences in pay and allowable differences in pay. Also, if you wish to rely on the any other factor catch-all exception, because, as I mentioned, there's no guidance or guidelines in the amendments of what other factor means, be prepared to justify differences in pay rates. And finally, you should determine standardized procedures for how employee wage review requests will be handled and how decisions will be communicated. And if you have any managers or supervisors at the front lines who may be recipients of these requests, ensure that they're trained and they understand what meeting the requirements and complying with the new equal pay for equal work provisions means.
Fabulous. Thanks so much, Laura. We can move forward now, I think, into the Q&A session. Just a friendly reminder to everyone, if you still have questions, now is your chance to submit them via the control panel on the right-hand side of your screen. I'm going to go ahead and get started with what we have so far. So the first one, Laura, is about the wage-based merit system. So what constitutes a system like that, and what do we need in terms of documentation? For example, if we give an employee a raise and document that the reason was due to, say, exceptional job performance, is this enough to be considered a system?
I would say that, it's best to be as transparent, and as upfront as possible, or practices that may be in place in your organization. It may not be enough to reactively try to justify, any of the exceptions apply. It's better to be able to point to something that's in existence that certainly sets out and establishes the basis for any type of wage, payments of wages as well as increases, et cetera, and that could result in the application of the equal pay for equal work provision. So kind of in short answer, as best as you can be upfront in your policies, in job postings, in job descriptions, or in employment agreements, the better.
Excellent. Thanks, Laura. Next question. We have restaurants in different cities. Can we have different rates in different cities for the same position?
Well, as it reads in the amendments, really establishment includes any locations that are within the same municipality. Yeah. So if it's outside of a municipality, arguably you could certainly, or in a different city, arguably you could have different wage rates, and it just bears and stands to reason because there are different cost of living considerations in various cities as well. So how the amendments read as it stands, I mean, the rubber hasn't fully met the road yet. It would be justifiable if you're in different cities or outside of different or distinct municipalities.
Okay, sounds good. Next question is about part-time employees. So what happens when part-time employees have fewer tasks than full-time employees, i.e. they do less work? Do they have to be paid the same rate as full-timers do, legally speaking?
If you can justify, based on kind of production or output, that employees will be paid differently, again, you're going to want to establish this as upfront as possible, because production or output are considerations that fall within the exceptions and could provide you with a justifiable basis to distinguish wage rates.
Okay, perfect. And you touched on this a little bit already, but our next question is looking at whether equal pay for equal work only looks at rates of pay, or does it also take into consideration other awards such as benefits coverage?
So rate of pay is a term that is referred to in the legislation. It certainly does not, in our interpretation, include benefits or, let's say, car allowances or those types of perks. It really will be based on wage rates, and that's what's going to be compared.
Okay. Excellent. And our last question for the Q&A period. Last call going out. If anyone wants to submit something, it is again the right-hand side of your screen. But our final question for the day, if a manager is not present for a few hours, we pay a server approximately $20 an hour to be the MOD, the manager on duty. Is this allowable, or do we have to pay the server the same rate of pay as a manager?
That's a good question. Well, if it's a couple of hours, it will be a couple of hours per.
I believe so, yes.
So if that's the case, then unless it's set out and there's a justifiable exemption or exception that you can cleave to, and if it's a part-timer that is performing these duties, then an argument could be made certainly that when the part-time employee is performing that type of work, that they should be paid at the same rate. But certainly, again, if there are any of the factors that could be applied that constitute an allowable exception, including any other factor that you could come up with to make the distinction between the work that is being performed on this kind of very limited basis with the work that the manager normally performs, then you should definitely leverage that.
Okay, that's great. Thanks so much, Laura. That brings us to the, oh, apologies. There are more questions. Okay. Apparently you all took me up on my offer. That's fabulous. Next question. Can I ask my employee why he or she is taking a personal emergency day off?
Oh, interesting. We're shifting gears.
We are slightly.
Okay,
no
I'm
pressure.
happy to. No, that's fine. So with respect to personal emergency leave, as most of you know, you can ask for the reason or the basis that the employee requires a leave day, but you cannot ask for medical justification with respect to why they have not attended their shift. So you can still ask for a reason, but you can't have that reason require the employee to provide you with a medical note to support the basis for them not attending their shift.
Okay. Excellent. Last question we've got officially. How does incentives pay if you are based on hours worked? So does a part-timer have to be paid the incentive as well?
So if incentive pay, like premiums, et cetera, would fall within the definition of wages. So for the purposes of wage parity, that would be included.
Okay, good to know. So that's great. I think that is officially the end of our Q&A session for today's webinar. We've got some great questions, and thank you to everyone who submitted today. Once again, our webinar will be made available in a few days, and participants will be sent a link to the webpage. If you have any other questions, please feel free to contact me. And with that, this concludes our presentation on Bill 148's Equal Pay for Equal Work webinar. I want to thank Laura Williams profusely for joining us here today and sharing her industry insights. And thank you all for tuning in, and have a great rest of the day.
Thank you.